Yes, RFA number 25 of 2022, having considered the submissions made by the learned counsels for both the parties, the instant appeal stands allowed, and the impugned judgment and order of the learned trial court in 48 slash civil suit 48 2010 stands stands quashed and disposed of. Yes.
Your Lordship.
Permission. Item number 2.
Your Lordship, may I make a mention for item number 1 of part 2? I've been asked by Mr. B. Ramega. He has some difficulties today for hearing.
What?
This
It was fixed
Yes.
for hearing today.
Yes. Some
What difficulty? Make an attempt. Isn't
may
it?
come up next week. He requested that he will.
Who's the counsel? Why are you all running away every time for hearing?
Respondent number 1, 3, 4, and 5.
Okay, this is, what about, any objection?
Yes, inform me this morning, so it's okay. Yes,
Okay. Mention is made on behalf of Mr. B. Lal Ramena, learned counsel for respondents number 1, 3, 4, and 5 for adjournment of the matter, since the learned counsel is not able to appear due to some personal difficulty. Good stuff. Mrs. Linda L. Fumble, learned learned PP for the state respondent is present and has not raised any objection. In view of the above, as prayed for, list this matter in the next week.
Obliged.
With regard to item number 3, this is another state appeal. This may be taken up after a week, my lord, since I was prepared for item number 1. I have not come prepared for this item.
Okay, who's the, okay. On the submission made by Mrs. Linda L. Fumble, learned PP for adjournment of the matter, which is not objected by Mr. Rosang Zolarante, learned amicus curiae for the respondent, list this matter after 1 week.
Permission. Item number 2.
May I please submit? My seniors on lacking the other code, so if this matter may kindly be passed over for the time being.
Okay, we'll make a time being matter. What is this thing?
Lordship, in this regard, I've already filed the affidavit in opposition on behalf of respondent number 7.
What about the other respondent?
Yes, Lordship, this yesterday I have received a telephonic information from the department stating that the respondent number 1 to 6 will be represented by the Commissioner CGST Aizol, and they said that they have dispatched the official letter day before yesterday, but I have not received till today. That hopefully I'll be receiving that one in a day or two. Then I may be given.
So respondent number 7 will be representing the other respondents.
No, Lordship, respondent number 7 already filed the affidavit in person, and 1 to 6 will be represented by the, if I'm not mistaken, Commissioner CGST Aizol. Because
So
Lordship,
is Commissioner CGST made a party?
no, not made a party, but respondent number 1 is the Union of India's represented by the Secretary to the Government of India, Ministry of Finance.
So if the commissioner here in Aizol is not impleaded,
Not impleaded, Lordship.
then he cannot represent. So this thing. So you make a submission. Do you have any this thing? No document to that effect.
Yes, I have not received till today, so I have contacted the department. So they have stated that day before yesterday they have dispatched the official letter, but I'm not still receiving that one. So I may be given time, Lordship, so that I have to look the matters whether he's able to
And
represent it or
then
not. Yes, Lordship.
if that is the case, then the counsel for the petitioner also will have to see
Yes,
whether
Lordship.
that can be done in
Very
this
true,
case,
very true, Lordship.
and whether he should be impleaded also.
Yes, Lordship. Then I may be given time.
So, mention is made on behalf of
My
Mr.
lord, please, if it can be passed over for the time being, my senior, he have some submissions to make.
You will list it tomorrow whether whatever submission it is, okay? Because
Tomorrow is
he-
Saturday, Lordship.
We'll
Monday.
list it on Monday,
Monday. Yes.
okay?
My lord, my senior will not.
And it's also, this is a more senior court, isn't it?
Yes,
You should
Lordship,
be
yes.
present here. Submission is made on, no, mention is made on behalf of Mr. Jordan Rohming Thanga, learned counsel for the petitioner, that the learned counsel for the petitioner is on legs in the other court, and that the matter may be passed over for the time being. Full stop. Mr. Johnny L. Tautong, learned counsel for respondent number 7.
All the respondents, Your Lordship.
Okay, counsel for the respondents submit that he has received verbal instruction that the respondents number 1 to 6 is to be represented by the commissioner, is it?
Commissioner, CGST Aizawl.
CGST Aizawl, and prayed that he may be allowed to submit such a written instruction in the next court date. In view of the above, list this matter maybe on Monday,
Tuesday.
on Tuesday. Why?
My senior will be out of station, my lord.
Okay, list this matter on Tuesday. To
Or
Tuesday
Lordship,
date.
maybe in the meantime also, I may.
What, you submit that, and then if they have to file an impediment, let them, this thing, isn't it? What's Tuesday's date? List this matter on 17,
17.
6, 2020. Right. This is a submit, let it be in
Sure,
a
sure.
written form, and then you can see, their counsel can also see.
Yes.
Yes. Yes.
Item number 3.
Yes.
Please, Your Lordship, my lord, ID card has not been yet received till date, my lord. So, my lord,
Okay, so notice
notice is not yet complete.
not complete.
Yes. So, if I may be allowed to serve dusty service.
Why?
Dusty notice.
Let's see, postal receipt return, okay.
It's already from March, my lord. March 27, maybe.
Heard Mr. L.B. Aknur, learned counsel for the appellant, who submits that service of notice upon respondents, how many respondents?
True.
Upon the respondents is not complete till date. Those steps were taken against the respondents on 27th,
Yes, my lord.
27/3/2025. The learned counsel for the appellant prayed that he may be allowed to serve notice to the respondents through dusty mode. Praise aloud. The learned counsel for the appellant to take steps for service of notice upon the respondents through dusty mode, and affidavit to that effect is to be filed accordingly. List after 3 weeks.
Vice, my lord.
Item number 4.
None appeared for the appellant on call. List after 2 weeks.
Item number 5.
May it please your lordship, I am appearing on behalf of the respondents 1 to 6. I am yet to receive the consolidated pairwise comments. So if 3 weeks time will be granted, your lordship.
Ms. Dalyan appears on behalf of the petitioners along with Ms. Lalman Lui, learned government advocate for the state respondents. The learned government advocate has prayed for time to file their counter affidavit. In view of the above, list after
3 weeks, Your Lordship.
3 weeks.
Much obliged, Your Lordship.
Order. Item 6.
Your Lordship, if I may, Your Lordship, the leading counsel for respondent number 10 is my senior, Your Lordship, and he's currently on legs on the other court. So if Your Lordship may give
Give
time,
us some other day, isn't it?
or Your Lordship, I could just fetch him after the next item. We would like to make submission regarding the item.
Have you filed your written objection?
Yes, Your Lordship.
Written objection both? Then can we hear the matter today?
Can hear, my lord.
Okay, time being.
Item number 7.
This is your lordship. This is an application for employment of the new incumbent to the post of Deputy Commissioner, District Collector, Kolasip District, my lord.
Okay. Heard Miss Valentina Naldinpui, learned counsel for the applicant who has filed the instant application under Order 1, Rule 10, read with Section 151 CPC for implement of the new incumbent, Mr. Robert C. Lalmangaya, Deputy Commissioner, Kolasip, Government of Mizoram, on the transfer of respondent
12.
number 12. We'll stop then. Miss
Baby Ladin Zwali.
Baby, so and so appears on behalf of.
Respondent number 2.
No, before that, issue notice, okay? Then Miss Baby, so and so accepts notice on behalf of respondent number.
The notice has not been issued, my lord. We have submitted an undertaking so that respondents can be,
No, issue notice to Miss Baby, so and so.
yes.
Learned counsel for respondent number.
Lordship, I'm appearing on behalf of respondent number 2 only.
Respondent number 2 and Miss learned government advocate.
Your
for-
Lordship, on behalf of P. Mary,
Okay, you're for respondent number, government advocate for respondents number.
14 and 12, 14 and 15.
For 14 and 15. No need to issue any formal notice to the said respondents. Considering this court, considering the nature of the submission made by the learned counsel for the applicant, find it appropriate to allow the application and accordingly implead what's his name?
Shri Robert Seal Mangay.
Robert C. Lalmangaya, Deputy Commissioner, Kolasip, as respondent number
18.
18 in the connected contempt case number
19 of 2022.
19 of
2022.
2022. Stop.
In the, if, my lord, if I make one submission, if the name of the counsel, Mr. Samuel Vanashat Atsangte, may kindly be removed from the list of advocates for the petitioners, my lord.
Okay, in the cause list.
Yes, ma'am.
WC. Why?
He has instructed me that since the respondents are government personnel, it was improper for him to have his name on the contempt case, my lord.
No, contempt, it's in the, okay, so he's for the petitioner.
Yes, my lord, in the
Oh, okay,
main,
yes,
main
yes,
case.
yes, okay, we will do that later. Accordingly, IA number 92/IA, within bracket civil, okay, 92/2025, stands allowed and disposed of. Now, in the main contempt, on the disposal of IA number 92/2025, heard Ms. Valentina so-and-so, learned counsel for the petitioner. The learned counsel for the petitioner is to file a corrected cause title and thereafter issue notice to the newly impleted respondent number 18, newly impleted respondent number 18 through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks. Full stop. The learned counsel for the petitioner has also submitted that the name of Mr. Samuel Vanlalshiata Changte, shown as counsel for the petitioner, may be removed since he is no longer representing the petitioner, being appointed as additional AG by the state government. Full stop. In view of the above, the registry to take necessary steps for removal of the name of Mr. Samuel Vanlalshiata Changte in the cause list in the instant case. Okay, but to take necessary steps and not to reflect, okay, the name of Samuel Vanlalshiata Changte as a counsel for the petitioner in contempt case number 19/2022.
Item number 6.
Yes. Who's the counsel who was supposed to appear? Huh?
He's coming, my lord.
Okay, we can, I think, proceed.
My lord. My lord, the present IA is an
IA is
application
for?
for condoning the delay of 311 days to prefer
Okay.
the,
Almost 1 year.
yes, my lord, almost, to prefer first appeal against order. And wherein, my lord, the impugned order, which is about to challenge in the FAO, is the order passed by the the trial court of
This
civil
is an
judge
FAO. Okay,
FAO,
so
my
the
lord.
civil suit is still pending?
Pending, my lord. Pending in the sense, the claim of the plaintiff is rejected by passing the impugned order. And what is remain is only with regard to the counterclaim made by the defendants.
Okay, and what is the dispute about? It is over?
The dispute about, the
Bone of
dispute is about
contention.
the land dispute located at Luang Mall
Okay,
area.
land.
Land, my lord. And where the present applicant is living within the suit land. And
You are living in the suit land?
I'm living in the suit land, my lord. I'm living in the suit land till date. And my lord, here, by passing the impugned order, the trial court had rejected the claim before the trial court by filing the civil suit. And if the present appeal is not considered by this appellate court, my lord, then I will have no other option to seek a remedy. So, in order
Okay,
to
what is the
admit
FAO?
the FAO,
What is the
the delay,
no, so the FAO is for setting aside of
setting
an
aside of the
order.
order, my lord. Yes, the order dated 23/8/2023.
What does it say?
But the
That year, this thing was dismissed on the grounds of what? because of
It is in
limitation,
Yes, limitation, my lord,
barred by limitation.
but by limitation.
So the case was not considered on merits.
Not considered on merit, my lord.
Then after that, you approach the court and again you have to apply for condonation. So why is this tardiness?
My lord, the thing is that initially, as a counsel, what I'd like to submit is that initially, at the time of filing the main civil suit, my lord, I'm dealing with the case. And after filing of the case for some time, the client had withdrawn the engagement due to, with their own volition, my lord, by engaging another counsel, my lord. And after that, the case was proceeded and the defendants had submitted an application for rejection of suit before the trial court, my lord.
So the order of the court the FAO is filed against an order wherein the trial court has said that your complaint was barred by limitation.
But by limitation, it was specifically article,
And then by Article 100 of so the matter was not heard on merits anyways,
not
isn't
hard
it?
on merit.
So now you have again approached this court after 311 days delay.
My lord, that is the thing.
That's why,
That
why
is-
this constant
that
delay in
delay-
every
that
time?
delay. Yeah,
Previously
that
also
is-
there was a delay, now again a delay?
That I have to explain, my lord,
Okay.
by filing the present IA, my lord. And here, initially, when the impugn order was passed, my lord, what I'd like to submit is that the issuance of the impugn order rejecting the suit by passing an order by the trial court was not intimated to me by the
Okay,
by
let's
the
see,
counsel.
copy 2. The order, the court must have, was a copy given to you? Let's see, what does the order say?
The copy is at page 8 of the IA, my lord.
16.
16, yes.
Copy of this order to be given to all concerned.
Yes,
So now you will have to check whether copy was given or not. Have you checked the, maybe the dark book or whatever as to how copies were given or not? That you have to have those documents to show that a copy was not given to you.
that is not available, my lord.
No, in the court, this is court, senior civil judge 4, so there must be some dark book, isn't it? Where copies are sent out, where the copy, because it says give a copy of this order to all concerned, okay?
My lord.
And your submission is that you did not receive this, a copy of this order, and you were not informed by your counsel, isn't
Yes,
it?
yes, my lord.
So now we'll have to see whether a copy was sent to you or not. Because the order says, give a copy of this order to all concerned. Now you're pleased that I did not receive the copy. So you have to take the trouble to go to the, maybe the judicial branch or something. Let me see the dark book they must be having, whether copies were actually issued.
My lord.
Copy of this order to all concerned. So we have
Well-
to see whether this order of the court, learned senior civil judge, was complied with or not, and copy was actually sent out. That you have to do your homework. If you're going to say that I did not receive a copy, I
That
was not
aspect-
informed.
That aspect, my lord, it might, so far as our understanding is concerned, my lord, the impugned copy, order copy might be served to the council, my lord. But
Might be served.
might be served to the council, the earlier council.
So find out in the dark book, isn't it? Copy to
Yes.
all concerned.
The
How is the copy dispersed then? You see, because usually, okay,
My lord.
what used to be done is copy two and then the names are given, the parties or the council, okay, name of the council representing this, okay. Here it is simply copy to all concerned.
My lord.
So who is the concerned? It would be the parties. So you have to find out whether copy was actually issued out to you or not. And whether it was given only to the council. If it was given, a copy was given only to your council and not, you were not addressed as one of the concerned, then maybe you can have a case. But when the order says copy to all concerned, then you have to show that copy was not issued to you, it was issued to your council. And then your council did not give you the copy. So that first step you
My
have to
lord.
do.
My lord, here in our application, my lord, what we have reflect is that the same was not the impugn order dated 23/8/2023 was passed by the trial court, and the same was not intimated to me by the council. That is my submission, my lord. That the issuance of that impugn order was not intimated to me by the council. Meaning
But was a copy sent to you?
no, my lord, not at all.
That's what we want to know. Copy to all concerned. It could be sent to you also. So you have to show that it was not sent to me, it was received only by the council. You see, you have to prove that you had not received a copy. It was given only to your council, and then the council did not tell you. Because in the court's order, it is copy to all concerned. So you have received a copy. It was sent to you because you were the party.
Yes, the thing is that, my lord, usually when the district court had issued the copy usually it used to be issued on to the clients through the council, my lord, generally. So,
No,
in the present
I don't
situation-
know what is the recent 10 now, but when we say issue copy to, we usually address the name of the parties, or if it is through the council, it used to be through the council.
Yes, my lord. So, my submission is that, my lord, we are prevented from
Okay,
acquiring the
anyways,
knowledge.
if you don't want to do your homework, copy, the court says copy to all concerned, so we presume that you must have received a copy.
Here, my lord.
But your submission is that you did not receive a copy, it
Yes,
was
yes,
received
it is-
by
that
your
is-
council.
That is not intimated to me by the earlier council. That is what we submitted before this court, my lord. And as soon as I acquired the knowledge, I had applied a copy of the impugn order on 5/6/2024, my lord. 5/6/2024 only. After a lapse of almost 5 months, my lord. Not more, yeah, more than that, my lord. The impugn order was passed on 23/8/2023, and I acquired the knowledge on 5/6/2024.
When was it intimated to your council? The previous council?
The previous council was intimated that
A copy?
actual copies serving the date, actual date was not reflected, my lord, here in our application.
So you're depending only on your application. You don't want to make any amendments to your application, making it more authentic?
My lord,
Simply saying that
that
I
regard-
received it, okay, 5
but
months.
in the regard, my lord, if I may be allowed to make the amendments, then I can make the clarification also, my lord.
You see, it is very general. I'm at this stage, simply saying I got to know it
That
late.
aspect of the matter, my lord, if I can clarify, then it will,
At least some documents to support
What you
that
done.
whether it's truthful or not.
My
Your
lord,
simple
exactly.
submission, okay. Then in all the other cases also, I received it late. That would be the submission.
in that aspect, my lord, if I may be given to make that clarification whether I'm receiving or not, or when the earlier council received the impugned order, that I may be allowed, my lord.
He has prayed for time to file an additional affidavit
My lord,
with some supporting document
my lord.
regarding his claim. We'll give him a time, let's see. Then you can file your, this thing, objection
By
to
way
the
of-
additional affidavit.
My lord,
It's so vague.
my lord.
This is basically in the interest of justice, considering the fact that the merits of the case has not been considered at all. I'm just thinking whether we can see whether there's a reasonable explanation to the prayer for condonation of the, FAO,
My lord.
isn't it? So let's see if he has any documents to substantiate his claim that he received this thing late. We'll give him a chance. Okay, then in the next
That's
court
okay,
date,
my lord. If your lordship may kindly see before that, one small submission, my lord. In the written objection filed by my learned friend, he had enclosed the order sheet of the trial court,
Okay,
wherein it is apparent that the counsel continues to appear after passing the impugned order. On 10 occasions, the applicant was duly represented continuously. The impugned order was passed on 23/8/2023, and in the suit was rejected in the stage of preliminary hearing on the grounds of limitation, as well as the plaintiff did not have the cast and die.
but he's saying that even though he was represented, he was not informed. So in the subsequent court dates, it appears that the issue of the counterclaim was considered.
Yes, my lord. Hearing was held on
But
the
supposing the counterclaim is not allowed, then what happens? The case of the plaintiff stands?
no, my lord. It is in our favor, in favor of the counterclaimant.
No, supposing the counterclaim is also dismissed, the court finds that it is, the counterclaim is not proper, then what happens? The plaintiff, this land will still belong to the plaintiff? or
No, my
what?
lord. It is in our
Then?
favor. It is in favor of the counterclaimants.
So, no, in the counterclaim, supposing the counterclaim is also dismissed, you're making the counterclaim, isn't it?
Yes, my lord.
So, in your counterclaim, you're saying that the suit property or whatever should be in your name. But supposing that is also dismissed, I'm just curious, what will happen then?
The plaintiff,
Because the
applicant
hearing continued regarding the counterclaim, where the plaintiff was
the applicant
also...
will continue remain in the sued land without possessing any pass, and will be the pass holder.
Okay, but he will be allowed to remain.
Illegal.
But supposing you're saying that I'm the pass holder,
Yes, my lord.
and in the counterclaim is what? What is the counterclaim regarding? What is your claim in the
We are
counterclaim?
objecting his claim.
Claim of what?
The same land.
The same land. So now you're objecting that and saying that that land should be in your name.
Yes,
is
my
it?
lord.
But supposing,
We are praying for-
supposing the trial court
Yes, my lord.
dismisses your counterclaim,
Yes, my
I'm
lord.
just curious, then what happens to the land? Now the plaintiff, because of being barred by limitation, his claim for this suit land is not considered. Now you have a counterclaim saying that this suit land should belong to me, and the plaintiff continues to be represented by his counsel in the counterclaim. Isn't it? If the plaintiff continues to be represented in the counterclaim
I understand,
and
madam.
your counterclaim is dismissed, then what happens? The land belongs to the plaintiff?
No, my lord. No, my lord.
Then?
We are the pass holder. He is illegal occupant, and in our counterclaim, we are praying entirely for eviction and demolition of the existing building.
Okay, for the eviction. So if your counterclaim is dismissed, he will not be evicted. Is it? If the counterclaim is dismissed, then he will not be evicted because the counterclaim is still considered and the plaintiff continues to be represented in the counterclaim as per your submission.
Yes, my lord.
So then what happens? I'm just curious. You see, because in the counterclaim, you're saying that the plaintiff, the counsel for the plaintiff is still appearing,
Yes, my
representing the
lord. Yes, my
plaintiff.
lord.
Then if he's still representing the plaintiff and the trial court dismisses their counterclaim, then the plaintiff will continue staying in their suit land? Or what?
Yes, my lord. It will have
So
to
it's a
happen like
little
that.
complicated, isn't it? Because the plaintiff is still represented, even though it says that he is barred by limitation, but in the counterclaim, if he's still represented, I'm just curious, what happens then? Then you will not have a case. He continues, then actually he wins, even though he's,
But he will remain an illegal occupant of the suit property.
that is your counterclaim. But
Yes,
if
ma'am.
that is dismissed because he's still represented in the counterclaim as per your written objection.
That is correct. He is still represented by his counsel. And now the counterclaim is in the stage of evidence.
Evidence.
It was already
So
maintained.
he's
the
still
counterclaim.
there in
Yes,
the
my lord.
counterclaim. And supposing a counterclaim is dismissed, what happens? He remains to stay in the land.
From the preliminary hearing of the counterclaim, prima facie, we have a case. That is why the reason that,
That,
the counterclaim is
everyone
maintained.
will say you have a good
And
case. That's
even
not
if this appeal is not filed by the present applicant, I understand that he still has an opportunity in the trial court.
he's still continuing.
He still has an opportunity to defend his case in the counterclaim.
In the counterclaim. And then, if the counterclaim is dismissed, he will not be evicted.
He will not be evicted.
So just think about that. I'm just this thing, because when you mentioned that he's still represented, okay, then anyways, so your counterclaim is that the suit land belongs to you and
Yes,
he
my
should
lord.
be evicted.
Yes, my lord.
And at present, in whose name is the land
Us-
registered?
the-
In your name.
you must-
Anyways, so we'll give him time. Let's see. His basic claim is that even though he is represented, his counsel has not informed him. So now the plaintiff is still engaging the same counsel or what?
My lord, at the
Who did
pleaded
not give you a
stage-
copy?
Yeah, later they returned to me, my lord, to take up the matter, my lord. And the earlier counsel had no more take up the matter.
So
as
in
of
the
now.
counterclaim, you're the one who's appearing.
No, my lord.
So in the counterclaim before the trial court, who's appearing? The same counsel?
But only at the bleated stage, my lord. Those order which are reflected and enclosed by my learned friend, during that period, we are not appearing, but only
Okay.
only at the later
So,
stage.
that counsel who is said to be appearing on behalf of the plaintiff applicant is now no longer engaged?
No longer, my lord, yes.
So he's not appearing?
No, my lord. After filing the present application, the present FAO, my lord,
Okay, in your written objection, let's see, what is the last date of his appearance? I'm just curious, I mean, we should have everything in before this.
The written objection filed by the respondent number 7, 8, 9, 11, 12, and 13, my lord. Joint written objection. The deponent is Zhou Ming Liana.
Okay, now will you be representing the applicant in the counterclaim now before the trial court?
He had,
Counsel for
he,
the
he
applicant?
had submitted his power of wakalatnama on
Before the
12
trial court.
September 2024.
Okay,
And if you also may kindly see the joint written
so your
objection.
case is not over yet, you still have a chance before
lord.
the trial court.
it's still pending, madam. But with regard to the pleadings, that was rejected already. What remains is only the counterclaim.
In the so the counterclaim is narrowed down to only whether you should be evicted or not. Yeah, I think that must be. That
My lord,
must
my
be.
lord, that is the thing. They are,
Whether he should be evicted or not. I think that's the only thing then.
Yes, my lord.
they also seek an appropriate order to declare that they are the genuine landowner by filing the counterclaim.
So if in the counterclaim, you pray that you should be the genuine landowner, and that is contested by the counsel for the plaintiff,
Yes, my lord.
Yes, my lord.
Then this,
Naturally, when praying for eviction, that ownership title has to be declared.
so his prayer in the plaint still survives when they have the chance to again counter your counterclaim.
He has an opportunity, yes.
Huh. It appears.
They have already filed a written statement against the counterclaim.
Counterclaim. So he's here, whatever he claimed in the plaint still survives.
Yes, my lord. Yes, my lord.
So even if this limitation is not allowed, you still have a chance.
But my lord, what we can do is that with regard to the
So
counterclaim,
this
my
is
lord,
very big. No,
only-
because I just want to make sure that justice is there for both the parties and a chance is given to the parties.
My lord.
But it appears that you still have a chance in the trial court, even if this IA is dismissed, because your prayer is very vague. No supporting documents for
But
the
my lord, in that
condonation.
regard, the majority
Simply
of,
saying I did not receive, I was not informed, at least affidavit should be filed by the council which was previously engaged, saying that I have not informed my client regarding this. Nothing is there. So I
but
think.
my lord, in that regard, I
Huh.
may be given at least a week time, my lord, and then I will file my.
I think we can dispose of the IA because it's 300 and something days. The case is still going on. And the justice is still there and for your side also because you are still representing. And whatever claim you made in your plaint, in your counterclaim, you are in the written statement through the counterclaim, you have chance to
But my lord,
highlight your case before the
with
trial
regard
court.
to the counterclaim, my lord, what we can do is to reply the counterclaim and make the objection and to pray the
So
court
in
to
the
dismiss the counterclaim.
counterclaim, I'm just, without looking at the documents, in the counterclaim, it appears that the defendants had stated that they should be declared the rightful owner of the suit property. Okay.
My lord,
Now, in your written statement, whatever grounds which you mentioned in your plaint, you can mention again in your written statement that this actually belongs to you based on this ground, and that you should not be evicted because the suit property belongs to you. So your interest is still surviving. You have a chance to present your case.
in that aspect of the matter, my lord, what we can do is only to reply the counterclaim. What are mentioned in the counterclaim, we can make the reply only.
So,
Majority of my pleadings in the main
So
suit
when you
are not
reply, when
mentioned.
you file a written statement, your claim that the land belongs to you can also be reflected. Because in their counterclaim, you have prayed that they have prayed that the suit property should be in your name. So in your written statement, you can say that it should not be because this is my case. So the matter is still going to be heard on merits by hearing both the sides, it appears.
My lord, but in that regard, majority of our pleadings are not pleaded again in the counterclaim, my lord. That is the main issue, my lord.
Why not? Why not?
Because when we
Highlight
that
everything?
is the reply to the counterclaim. my lord. Reply to the counterclaim in the sense only those paragraphs mentioned in the counterclaim.
What
are
is the
specifically
counterclaim?
replied.
What is the counterclaim?
The counterclaim is.
Have you filed your written statement?
I have filed the the reply to counterclaim I have filed. But majority of my pleadings in the main suit are not reflected again, my lord. That is the main problem, my lord.
If that is the submission of my another friend, my lord, in the trial court, my lord, the evidence is yet to be started, and at this stage they have an opportunity to take appropriate steps for amending the written statement or improving the written statement.
You can incorporate everything. You have a chance.
In
Simple.
that
As per law,
aspect-
as per law.
In that aspect of the matter, my lord.
Anyways, we'll give you a chance to file any additional document to support your prayer for condonation.
My lord.
See, because the concern of this court is a chance should be given whether it would be appropriate or not. Let's see. We'll give you some time. If you don't have sufficient documents to satisfy the court that your claim that a copy was not given to you is not substantiated by any satisfying documents, then there's no ground for allowing the condonation of 311 days.
Mal.
That's his only
we'll do
plea.
that,
He
ma'am.
doesn't have any other submission. It was not given. But then he could be some villager, innocent person, not knowing. So we'll see. We'll give you a chance. Yes. Okay. I heard Mr. Yes, okay, heard Mr. F. Laleeng Diana, learned counsel for the applicant, along with Mr. Victor L. Ralte, learned counsel for respondent number
10.
10, and Mr. Subedi, learned counsel for respondent number. Your name is not reflected no, in the IA.
7, 8, 9, 11, 12, and 13.
In the FAO.
Yes.
But your name has not been reflected in the IA. That's what I'm just. Anyway, for learned counsel for respondent number 7, 8, 9, 11, 12, and 13, and Miss so and so learned government advocate for respondents number 1 to 6. 1 to 6. Have you filed? Are you filing any written objection? No. Pro forma. Okay. On hearing the submissions made by the learned counsels, the learned counsel for the applicant is given time to file an additional affidavit to substantiate his explanation given for the delay of 311 days in filing the connected FAO 6/2024 against the order of the learned trial court dated 23, is it?
23.
23/08/2023 in civil suit number what?
Civil suit number
FAO arising out of?
25 of 2016.
Okay, 25 of 2016. Matter be listed after 1 week.
Mal.
Can we have fixed date, my
Open.
lord?
On, give a date,
1st of July?
on 1/7/2025.
Not obliged.